Leanne Dalzell.
My involvement in this piece of legislation that we have before the House dates back to 2003 when I was an Associate Minister of Justice and was instrumental in establishing the Trans-Tasman Working Group on court proceedings and regulatory enforcement. And that's where the whole process began. And I guess that it's therefore particularly satisfying that I'm able to contribute to the final set of legislative steps that need to be taken for it to be enacted. There obviously was a lot of water under the bridge since 2003, and it was actually just a matter of luck or chance that I was able to step in for the Attorney-General at the time and in fact sign the agreement between the Government of New Zealand and the Government of Australia on Trans-Tasman court proceedings and regulatory enforcement. And I've even brought a copy of it down to the House because it does have my signature on it, and I'm kind of proud of that, on behalf of the Government of New Zealand and, of course, the Attorney in Australia at the time, Robert McClelland, signing for the Government of Australia, and still the Attorney at this stage. And so, the reason that I wanted to mention this is that I had the wonderful opportunity of being hosted to the signing ceremony, which was conducted at the High Court in Christchurch, which of course is my hometown. And there aren't going to be many opportunities in my life where I get to sit on the bench of the High Court, but I did have the opportunity on that occasion, and it was a great honour to be able to do that. And I just thought it was worthwhile actually reading out the preamble to the agreement that we signed that day, because the preamble actually encapsulates the essence of the legislation that we have before the House and will conclude its stages while we're in urgency. The first, the Government of New Zealand and the Government of Australia, conscious of their long-standing friendship and close historic political and economic relationship, recognising the development of that relationship through the framework established by the Australia-New Zealand Closer Economic Relations Trade Agreement done at Canberra on 28th of March 1983 and subsequent arrangements and agreements developed within that framework of which this agreement forms a part, acknowledging each party's confidence in the judicial and regulatory institutions of the other party, affirming their shared commitment to appropriate and effective resolution of Trans-Tasman civil disputes and increased regulatory cooperation, desiring therefore to establish a new Trans-Tasman regime building on the existing cooperative regime covering the taking of evidence and associated court procedures to further streamline aspects of civil court proceedings and regulatory enforcement and reduce unnecessary procedural and regulatory barriers to the conduct of litigation, have agreed as follows. And there follows a number of pages to the agreement and the articles, of course, that represent what has now been translated into the legislative form that we have before us in the House. And I think that what we have seen happen over the period that I've mentioned from 2003 to 2010 has been a significant step, because it has been the willingness on both sides of the Tasman to place trust in each other's judicial and regulatory processes, and I think that is absolutely fundamental to the development of the single economic market that the Attorney spoke about. The proposals in that agreement took the innovation and cooperation that had already existed with CER to a new level, and I think has established itself as a very important fundamental from a civil justice perspective, as it will improve the resolution of legal disputes that involve parties and or assets on either side of the Tasman. Looking at the magnitude of the problem, I reflected back on the regulatory impact statement because, in a way, tragically, this was one of the last pieces of legislation that was tabled in this House that actually had the regulatory impact statement included in the body of the bill. But the useful thing about having this information at hand when we are debating legislation is that it does give us the statement of the problem that the legislation is designed to address. And I think it is instructive to look at what that actually means in the context of this piece of legislation. Here we have a statement of the magnitude of the increase in the movement of people, assets and services between New Zealand and Australia, and I think they are worth recalling for the record. In 2006, over 900,000 Australians visited New Zealand and well over 1 million New Zealanders visited Australia. Almost 450,000 New Zealanders live in Australia and around 60,000 Australians in New Zealand. In the year to June 2006, it's a little bit out of date now, exports of goods from Australia to New Zealand came to New Zealand 7.641 million, and from New Zealand to Australia, to New Zealand 6.806 million. In the year to September 2006, New Zealand exports of services to Australia came to New Zealand 2.387 million, and Australian exports to New Zealand came to 3.588 million. As at 31st of March 2006, total Australian investment in New Zealand was in the region of 68 billion, and total New Zealand investment in Australia was in the region of 25 billion. And the point that's made in the regulatory impact statement is that this leads inevitably to a greater number of disputes involving individuals or businesses with a cross-border element. Under the Australia-New Zealand CER agreement and the work around achieving a single economic market with Australia, each country also has a significant interest in the effectiveness of existing regulatory regimes, such as the Commerce and Securities Acts and their Australian equivalents, to ensure that limits to the reach of each country's regulatory system are not exploited and that consumers have effective redress. And I think the fact that it actually mentions the importance of ensuring that the reach of each country's regulatory system are not exploited actually points out the reality of the situation where you have to rely on one or the other, because there can be an element of regulatory arbitrage to avoid the occurrence of or the enforcement of proceedings in one jurisdiction by simply removing oneself to the other and expecting that to be addressed in that context. When I signed the agreement on behalf of the New Zealand Government, I also commented that in my role as Minister of Commerce, I could see some very broad benefits to the approach that was being adopted, as well as facilitating the effective resolution of legal disputes. The arrangements for regulatory enforcement are very important in that CER context, and will certainly support the then recently implemented arrangements for Trans-Tasman securities offerings, the operation of the Trans-Tasman Mutual Recognition Arrangement and future coordination initiatives. So it really does not only deal with current situations in terms of those, in terms of the proceedings on both sides of the Tasman, but actually a good platform for other initiatives taken under the umbrella of the CER and SEM agenda. Mr. Speaker, the last thing that I thought that I would mention is that although I didn't sit on the Select Committee that considered it, it's clear from the report back from the Select Committee that they undertook quite a detailed analysis of the legislation and picked up some of the issues that the Attorney mentioned in his comments in the House, and have, I think, considerably improved aspects of the bill in order to address the concerns that were raised in submissions. And I think one of the areas of concern that had been previously raised by way of public comment on the legislation was the concern about the proposed recognition and enforcement of regulatory sanctions, identifying it potentially as perhaps the most controversial part of the regime. And I think the argument was that they were considered to partially displace the long-standing rule that domestic courts do not enforce penal as opposed to compensatory laws of foreign states, because to do so is contrary to the principles of independent sovereignty. But given that that's rather a big issue, I might leave that to the committee stages of the House.
I call